When you fall asleep at your desk reading case law, office supplies get in the darndest places. Happy Tuesday, everybody. I'm Brian, and this is the morning report on the federal courts for September 23rd, 2025. Do me a favor, tap your screen, comment on whether you've seen the birds migrate yet, and try to watch at least a minute, even if you're coming back later. It really helps me hit the FYP. Now, grab your coffee and strap in. We're going to start with a really big one here. You ready? Okay, let's talk about Luigi Mangione's case, where last week the state of New York dropped two big charges, but left open some big questions about remaining about federal charges and the Fifth Amendment. Now, I'm going to be a little careful with my algorithm language here, so forgive me for that. First thing you have to know is that there are two different cases against Mr. Mangione. One is brought by the federal government, one is brought by the state of New York. Both are charging him with very similar crimes stemming from the same incident, or similar anyway, and we're going to talk about how this is possible in just a couple minutes. But first we're going to discuss an order that was issued in his New York state case. So this was in response to a big motion that Mangione filed requesting a lot of different things. Some of them were granted, some of them weren't. We're going to run through them. First, he asked for some extra procedural hearings, and for today I'm just going to tell you he was granted Huntley, Mapp, and Mosley hearings. Just going to leave it there. Then we sort of have three other big issues here. One is that he has been charged with two terror-related charges for which he says he doesn't meet the criteria. And then he filed a motion to dismiss based on double jeopardy and a motion for a stay of the state case until the federal case is complete. So first we're going to hit the terror question. So you guys have seen Law & Order. You know there are degrees of crime, right? You've got Man 1, Man 2, and the bigger ones I'll just call M1 and M2, but you know what I mean. Well, in New York, M1 is usually M plus something very specific. There's a very precise list, and it can be anything off that list. And one of the things off that list is committing M with an intent to terrorize. Then there's M2, which is a lesser offense with a lower sentence. But for some reason, and I can't totally figure out why, there's a version of M2 that is M2 plus terror. And if they convict you of that, it just becomes M1. So I don't know why they have both, but maybe it's easier to convict people of M2. I have no idea. But it's important to know that terror means something very specific. Actually, it means one of three very specific things. You can't just say people were scared, therefore it was terror. No. It has to be something, one of these very specific things, and I don't have time to break them down here, but the court does in great detail. You can go take a look if you want. They're on my shared documents. Now, Luigi has 12 charges in New York State. 3 of them are actually related to unaliving. He has a regular M2 charge, just the plain old M2, an M2 terror charge, and an M1 terror charge. And last week, the court looked at the definition of terrorism, those 3 things, and compared it to every version of what Luigi had been accused of doing to see if there was any legal way that it could fit into one of those 3 definitions, and the court found it did not. Court found that Luigi's intent was to draw attention draw attention of the public to the greed and bad actions of a particular corporation, not to terrorize people based on the definition of terrorize in these statutes. And again, the court went down all kinds of little rabbit holes. It'll take too long, but you can go look at it yourself. So as a result, both of those charges have been dropped. The remaining charge of plain M2 is the only one that stands in the state case, along with much lesser charges. Now, there's still a federal case, and Mr. Mangione had 2 more requests in this motion. One was to dismiss on double jeopardy grounds, and because he's being tried in both federal and state courts. The other was to stay the state court trial until after the federal court trial. And the court addressed these together. They kind of breezed past them, to be honest. But still, I'd like to take a minute to talk about double jeopardy and the Fifth Amendment here. I did a live on this the other night. You can go watch it on YouTube, but this is just going to be a quick recap. So the Fifth Amendment says that essentially you cannot be tried twice for the same offense. And so how can Luigi be tried in both state and federal courts for the same actions? Well, there is a 2019 case called Gamble v. US that addresses whether a single crime can be tried in both state and federal courts. And it relies on a very old doctrine called the dual sovereignty doctrine. This case is also in my shared documents with all the rest of this. You can go take a look. It's actually really complicated. I'm going to try to give you a short answer, which is not going to be at all satisfying. May give you more questions than answers, but at least you'll have some sort of an understanding what the arguments are that are kind of underlying this. So I'd say there are two main parts to this. First, the Constitution says that you can't be tried twice for the same offense, not that you can't be tried twice for the same action. In fact, Luigi has 7 different charges for possession of a firearm, most of which are probably the same firearm, but the offenses are different. One is criminal possession 2, one is criminal possession 4, etc. And the second part of this argument is that once we recognize that first part and we allow multiple charges from, say, the state of New York for the same action, as long as the offenses are different, then it's kind of a short walk to recognizing that the state of New York's M1 statute and the federal government's M1 statute may be very different and may criminalize very different things. And that's the underlying theory of what's called the dual sovereignty doctrine. So dual sovereignty says that when you are under 2 different sovereigns, in this case the state and the federal government, and break both of their laws, you have broken 2 different laws, not the same offense. And that's how you can be charged for breaking both. Now, don't get me wrong. I see some pretty big holes in this. And by the way, the scorching dissent in this case from Justice Gorsuch is well worth a read. But this is a very short and incomplete introduction to this argument. Luigi's argument was denied, as was his request for a stay. He's filed a similar motion in federal court, so we'll see how that does, and I will tell you guys when we hear. But Gorsuch did not like this, so he may have a different level of support now. You can read through all of these in my shared documents. I highly recommend it. It's in the, I believe, the crime folder, so give it a look. All right, that was a big one. Now we're going to hit slaughter, also a big one. Yesterday, the Supreme Court stayed a lower court order preventing the president from firing a member of the Federal Trade Commission. Now, we have talked about Cook v. Trump, which is the same situation for a member of the Federal Reserve Board. These are connected in theory, but not the same case. The issues are not perfectly parallel. Make sure you keep an eye on them separately. The FTC deals with trade and with other countries. The Federal Reserve Board sets our interest rates. Both are very important, and it's been considered very good policy to keep members of these groups insulated from politics in the past. And for about 100 years, a case called Humphrey's Executor, which is also in my shared documents in the subject matter library under foundational cases, dealt with exactly this question of whether a president could fire a member of the Federal Trade Commission. And the conservative majority in the Supreme Court very much apparently wants to overrule this decision. But that's not what they did here. Let's be clear. The Supreme Court stayed the lower court's decision. And I'm going to take a moment to explain to you why the difference matters, even if and when the outcome may be practically the same. If you throw up your hands today and say the Supreme Court has overturned Humphrey's Executor, now the president can just fire anyone he wants, but in 3 months the Supreme Court issues an opinion that is very nuanced and overturns Humphrey's Executor in only one limited situation, like when the law creating the position was written in an unclear manner or something like that. The president could just take that opportunity to declare victory and start firing people he does not have the power to fire, and those of you who weren't paying attention will not get mad at him, you'll get mad at the court. And you won't push back against this hypothetical illegal firing, you'll start complaining about how it's the court's fault and they should all be impeached. And this is why precision and clarity matter today. Again, I'm not saying any of that will happen, I'm saying this is why it's important to pay attention. So let's talk really quickly why the court stayed this decision, because I've seen a lot of complaining in my comments about why the court sided with the president here and the irreparable harm to Ms. Slaughter. So we don't have a substantive answer from the majority, but based on the government's argument as to why a stay should issue, we can make a wild guess. The FTC sets U.S. policy, and by keeping the president from putting the person he wants in charge of it, if he is in fact allowed to do that, then there is a major harm to him and possibly the whole country because they can't achieve the goals they want to achieve in global trade. So balancing the harm against the whole country and possibly the world against the harm to Ms. Slaughter for losing her job, the court may have decided that the harm to the country was greater. I can only guess here, but there is at the very least a logic to that, and It's not just we don't like her, the end. Now, once again, we had a strong dissent from Justices Kagan, Jackson, and Sotomayor, which largely focused on using the shadow docket to make major reasoned decisions. Definitely is not its purpose, but the court will hear this case and has directed the parties to brief the following questions. 1. Whether statutory removal protections for FTC commissioners violate separation of powers? If so, whether Humphrey's executor should be overruled? And finally, whether the court may prevent a person's removal from public office, whether through equity or law, which is definitely a question, I'm guessing, written by Justice Barrett, but again, a guess. So once again, this fall is going to be interesting, so buckle up. All right, last case, AFL-CIO, another AFL-CIO case. This one is a challenge to the large-scale reductions in force. One of the problems early on with this case is that the plaintiffs couldn't challenge specific actions because the government wouldn't turn over copies of the actual RIF documents. The government said the plans were still being negotiated, and turning them over would hurt the negotiation process, something called a deliberative process privilege. Basically, if there's internal deliberations going on, like a contract negotiation that would be damaged by letting people see it, sometimes a privilege can be asserted. But the Ninth Circuit said on Friday this is not one of those cases. This only applies when the deliberation is something so hot, so candid, or so personal, public disclosure would stifle honest communication, and there's no evidence of that here. So the Ninth Circuit said no. Now, this has been stayed by the Supreme Court waiting for this response. Ninth Circuit has essentially sent it back down to the district court. Now it might finally be able to move forward. All right, that is your Tuesday morning report on the past day in federal courts. So thank you all very much for watching and have a wonderful day.